Hello all, this would be our fourth lecture on our series of lectures with regard to most important topics for the Prelims exam 2023 for Indian polity. For maximum benefit, try to watch all the classes so that you don't miss up on any important topics that may be relevant. So let us move directly to the first question. Consider the following statements regarding the Enforcement Directorate. So this question is related to this particular institution, Enforcement Directorate. If you see the last one here, this is one of the institutions that has been reported the most. It has filed a number of cases against many politicians, against various organizations, financial institutions, and in fact there is also a media reports which says that the government has been misusing this Enforcement Directorate to silence the voice of opposition, but that's an allegation. We are not sure as to whether it is true or wrong, but anyways, putting that aside, let us directly get into the question as to how it is relevant for the examination. Let us see a few information before we proceed further. Enforcement Directorate. In the year 1956, so this is the genesis of this particular institution. In the year 1956, an enforcement unit was brought in under the Ministry of Finance, Department of Economic Affairs. So initially this unit was established under Department of Economic Affairs. What is the objective? To enforce and to prosecute the violators of the Foreign Exchange Regulation Act 1946. So this was the objective with which it was established. And then it was renamed as Enforcement Directorate, ED, and the administrative control has been transferred from Department of Economic Affairs to Department of Revenue, Ministry of Finance. So right now it is under the control of what? The Department of Revenue under the Ministry of Finance, and it continued carrying out the same function, but over a period of time the scope and the function of this Enforcement Directorate has been expanded because of the gravity of the offences under these laws. Let us just understand as to what are their functions. But before that, if you see, this organization is headed by an officer of the rank of director, and mostly all these officers come through deputation from the central services, and especially from the Indian Revenue Service and from two other All India services, Indian Administrative Service and Indian Police Service. But the officers from the other services can also be deputed. The director is usually given a term of 2 years, which is mandatory under the CVC Act 2003. CVC Act 2003 mandates that anybody who is appointed as a director should be given a minimum term of 2 years. And further, even after the completion of 2 years term, their term can be extended by another 1 year, and it can be extended for 3 times like that under the Act. So these are some of the factual information that you'll have to understand. But over a period of time, the function of this Enforcement Directorate has been expanded. And right now, if you see the scope and function of this Enforcement Directorate, they not only implement the FERA Act, they not only prosecute the violators of the FERA Act, which is now anyways renamed as the FEMA Act, Foreign Exchange Management Act 1999. And in addition to the FEMA Act, it also implements the prevention of the economic offences under the Prevention of Money Laundering Act 2002. In addition to Prevention of Money Laundering Act 2002, it also today enforces the Fugitives Economic Offenders Act, which was passed by the Parliament in the year 2018, mainly to prosecute the people who have engaged in serious economic offences and has left the country. And in addition to that, they also implement an act which is called as the Coffee POSA. Coffee POSA Act 1974. So all these acts are today under the jurisdiction of the Enforcement Directorate. Now, Enforcement Directorate is under the administrative control, as I already said, Ministry of Finance under the Department of Revenue, and it is a body which is established by an executive order. So these are all the basic information that you should have with regard to the Enforcement Directorate. So with this information, let us try to solve the question. First statement. The Directorate is a multidisciplinary organization majorly mandated with the investigation of offences related to money laundering. Yes, of course, money laundering under the Prevention of Money Laundering Act, but it also enforces the violations under the other act as well, and violation of the foreign exchange laws. Of course, the FEM Act. These are the two major things, but they do involve in the implementation of the other acts as well. So statement 1 is right. Come to statement number 2. The Directorate is under the administrative control of Department of Economic Affairs, Ministry of Finance. So although it is under the Ministry of Finance, it is not under the Department of Economic Affairs. It is under the Department of Revenue. Statement 3. The Directorate is headed by an officer of the rank of Director who is minimum appointed for a term of 2 years. That is very much true under the CVC Act. A minimum term of 2 years has to be given so that there is some kind of stability for the officer to look into the various duties so that he is not under undue political pressure. So this is the objective with which this particular thing has been provided. Okay. So which of the following statements given above are incorrect? Well, statement 1 and statement 3 is correct. The incorrect statement is option 2. So the right answer would be option 2. Okay. Let us quickly move to the next question, which is again very important for this year's examination. Similar to that of Enforcement Directorate, one act that has been repeatedly coming in the newspaper is the Prevention of Money Laundering Act. A number of cases has been filed by ED on the grounds of people who have engaged in the money laundering activities, and here also there is an allegation against the government that the government is misusing this Enforcement Directorate and the Prevention of Money Laundering Act, especially to suppress the voice of dissent in the democracy. Anyways, let us just try to understand the provisions of this Money Laundering Act, which has also been challenged in the Supreme Court on number of grounds. The Supreme Court has upheld these provisions, and they said that considering the gravity of and the seriousness of this offence, these provisions has to be part of the Prevention of Money Laundering Act, and that does and it does not violate any of the rights of the people. So first let us try to understand as to what does it mean by money laundering. So that's a basic question. So to understand money laundering, let us assume that certain amount of money has been acquired by an individual through certain illegitimate means, let us assume. So the money has been acquired through illegitimate means. The money that has been acquired through illegitimate means has been converted as if the money has been made through a legitimate means, or you can say legitimate source. Understand, the money is initially created by an illegitimate source. It was amassed by an illegitimate source. It can be through corrupt activities. It can be through gambling, terrorist funding, whatever be it. But that money is converted as if the money has been made through a legitimate source. Say for example, that the money that has been acquired through illegitimate source is converted into a legitimate source through, let us assume, a profit as if it is made from a shell company. A company does not exist actually, it exists only in paper, but you show profit from that particular company, and that is how you can convert this money to be a legitimate source. Or it can be in the form of some funding which a trust receives, and a person who is making money can own a trust and he can bring in donations to that particular trust, show it as an legitimate money. So the entire activity is illegal in our country. The entire activity is illegal in our country, and this illegal activity is what is called as money laundering. So anybody who is engaging in such an activity can be considered that he is engaging in what is called as money laundering. The gravity of this particular offence has been realized in the year 2002. Then NDA government has brought in this particular act, the Prevention of Money Laundering Act, in the year 2002. The subsequent Congress government had amended some of the provisions and has made it even more stringent, and which is now widely implemented by the present government. Okay, so this is the background of this Prevention of Money Laundering Act. A number of people from the opposition parties were charged under the Prevention of Money Laundering Act. They have moved to the Supreme Court, challenged various provisions of the Money Laundering Act. In this context, let us try to understand the question. Statement 1. The Act empowers the Enforcement Directorate to investigate, to conduct, search, and to make raids, arrest, and to confiscate property of the individuals engaged in money laundering. This is one of the most important provision of the Money Laundering Act. So, whenever a case is filed, the Enforcement Directorate has the authority to make investigations, conduct searches and raids in the premises of those people, and they can also arrest the individuals and they can confiscate the property as well. This is very, very important. They can take up the property which they have acquired through illegitimate means, and for those individuals who engage in money laundering. So, this statement is very much true. Come to the second statement. Under the Act, it is mandatory for the Enforcement Directorate officials to provide the copy of Enforcement Case Information Report, ECIR. So, just to draw a parallel, this ECIR is similar to that of an FIR which the police files. Whenever you go to a police station, when somebody files a complaint, and after making a preliminary inquiry, the police files a first information report which briefly discusses the charge against a particular individual. Under the Criminal Procedure Code, it is mandatory for the police to hand over a copy of FIR to the concerned individual against whom the FIR is filed. So, this is mandated. But however, if you see, under the Prevention of Money Laundering Act, it is not mandatory for the Enforcement Directorate to give a copy of this ECIR, Enforcement Case Information Report, and this provision was challenged in the Supreme Court recently. The Supreme Court said an FIR cannot be equated to that of an Enforcement Case Information Report because this is majorly used for an internal purpose, and hence there is no need to give this document to the accused. It is sufficient enough if the accused is informed of the grounds of arrest. There is no need to give this Enforcement Case Information Report. So, with this information, just let us try to solve the statement. Under the Act, it is mandatory for the Enforcement Directorate officials to provide a copy of Case Information Report to the accused. So, this is not mandatory. Okay, so this particular statement is wrong because of the word mandatory in it. Come to statement number 3. As per the Act, statement made by the accused cannot be used as an evidence against him in a court of law. So, we'll try to understand whether this is right or wrong. But before that, under the Indian Evidence Act, which applies for most of the criminal laws in our country, and also under Article 20 of the Constitution, which also provides for right against self-incrimination, no confession or no statement made by an individual in front of a police officer or any confession made in front of a police officer cannot be used as an evidence against him. So, that is protected both under Article 20 because they have the right to not to be self-incriminated. Okay, so that is provided under Article 20, and the same is also given under the Indian Evidence Act. But however, this does not apply in case of the Prevention of Money Laundering Act. In fact, under the provisions of the Prevention of Money Laundering Act, the statement which is made by an individual to the investigative officer can be used as an evidence in a court of law. And this provision was challenged. But however, the Supreme Court has upheld this particular provision, and the Supreme Court said that there is no clash with Article 20 of the Constitution because the investigation which is done by the Enforcement Directorate is not equivalent to that of an investigation which is done by the police, and the Enforcement Directorate officials are not equal to police, where police does investigation, where they do only inquiry, and hence there is no violation of Article 20. This is the opinion of the Supreme Court. So, with this information, try to solve statement number 3. As per the Act, the statement made by the accused cannot be used as an evidence in a court of law. It can be used as an evidence. So, this particular statement is also wrong. Come to statement number 4. Under the Act, money laundering is a cognizable and a non-bailable offence. So, what is a cognizable offence? A cognizable offence is something that an individual can be arrested without a warrant. There is no need for a warrant from a judicial magistrate because the gravity of the offence is so serious, he can be arrested. Non-bailable offence. In this particular case, the bail is not a matter of right. Otherwise, in case of bailable offences, bail is a matter of right for an individual. Unless and until he is found guilty, he can be on bail. But in this case, the bail can be granted only at the discretion of the judicial magistrate. So both the things are true. So under the Act, money laundering is a cognizable and non-bailable offence, and also the burden of proof lies on the accused. If you see the general criminal jurisprudence or the principle under the criminal law, an individual is found to be innocent unless and until he is proven guilty. That is the normal jurisprudence. That's a normal principle. But however, in this case, the principle is a little modified, that once a case is filed, it is the responsibility of the individual to prove that he is not guilty in a court of law. And in fact, this provision was also challenged, but the Supreme Court upheld this particular principle, looking into the seriousness of the offence and the gravity of the offence. So this particular statement is right. So with this, which of the statements given above are correct? Well, statement 2 and statement 3 are incorrect. So the right answer would be option 1 and 4 only. Let's move to the next question. The next question is with regard to the Attorney General of India. Why this topic is very important? Because last year in the September, the term of then Attorney General of India, Mr. K.K. Venugopal, term has come to an end, and subsequently the government has appointed Mr. R. Venkatramani as the new Attorney General of India. So this topic is very important. Otherwise also Attorney General is a very important topic. And what are the articles that you should be aware of to deal with the Attorney General of India? You should be aware of Article 76, because it is under Article 76 of the Constitution, the President can appoint the Attorney General of India. Article 88. Article 88 also allows the Attorney General of India to take part in the proceedings of the Parliament. We will discuss that. And also Article 105. I will discuss as to what is the relation to Article 105 as well. So these are the important articles you should be aware of when you deal with the topic Attorney General of India. So we'll just see the statements and then we'll try to understand how it is related to these articles. Statement 1. The Attorney General of India is appointed by the President. Yes, that is true. He is appointed by the President. And he is usually appointed by the President on the aid and advice of the Council of Ministers headed by the Prime Minister. So here it is saying the Attorney General of India is appointed by the President of India based on the recommendation of a select committee. There is no such provision in the Constitution, headed by the Prime Minister along with the leader of opposition in the Lok Sabha and the Chief Justice. Okay, so this is just a distractor. So there is no such provision. It is basically the Prime Minister recommends, and then the person is appointed, and he is usually appointed for a period of 3 years. And it is also very important that you should know that the Attorney General occupies office during the pleasure of the President. That means he can be removed at any point of time by the President of India. That means basically it is at the pleasure of the government who may recommend the President. And normally who is appointed as the Attorney General of India? Somebody who has an eligibility to be appointed as the Judge of the Supreme Court. So all these things you'll have to understand. Now in fact this Attorney General is the first law officer of the government. The government might have a number of law officers. In fact the government is the single most largest litigant in the country. The central government is the single most largest litigant in the country, and to defend the government you need to have a group of law officers. And who is heading all the law officers? It is the Attorney General. He appears in most of the important cases of the government, and to this extent he exercises certain privileges. He has the right to audience any court in India. He doesn't have to seek anybody's permission, and he defends the government in all the legal matters, in all the cases against the government, and any other legal duties which may be entrusted by the President from time to time. So this is basically his nature of his duty. Now come to the next statement. The Attorney General is the first law officer of the country and is also a member of the cabinet in the government. So this statement is partially true. The Attorney General is the first law officer of the country, but he is not a member of the cabinet of the government. So similar system is followed in certain countries like UK even today. In America also, United States of America also, they follow such a system. But that is not true in case of India. He is just an officer. He is not a member of the cabinet. He is not part of the Council of Ministers, or he is not given the cabinet rank. Third statement. The Attorney General has the right to take part in the proceedings of the Parliament and its committee, and is also entitled to vote in the houses of the Parliament. Now, because the Attorney General has to defend the government in a court of law, sometimes the Attorney General can also be called upon to participate in the parliament, in the parliamentary debates and in the parliamentary committees and all those things. And that's why Article 88 of the Constitution gives him the power to take part in the proceedings in the parliament, in the parliamentary proceedings, and he has the right to speak in the houses of the parliament. But however, please understand, that does not give him the right to vote. He can only take part in the proceedings, talk in the proceedings, express his opinions, but he is not a member of parliament and hence he does not have the right to vote. So this is what Article 88 of the Constitution says. And further, what is Article 105 of the Constitution? We already discussed Article 105 of the Constitution provides certain privileges to the members of the parliament. And if you come to Article 105, it also talks that not only the members of the parliament, anybody who takes part in the proceedings in the parliament, they shall also exercise such privilege as that of the members of the parliament. So whenever the Attorney General takes part in the proceedings in the houses of the parliament, he shall also exercise such privileges as it is given to the members of the parliament. The only difference is, while the members of the parliament shall not be liable for any proceeding in a court of law for any vote that they have exercised in the house of the parliament, the Attorney General does not have the right to vote. So that privilege is not there, but otherwise he can express his mind. Okay, so that privilege is given to the Attorney General. Okay, so with this information, which of the statement given below is or correct? The correct code is, so you have seen statement 1 is wrong, statement 2 is also wrong, statement 3 is also wrong. So nothing correct. So the right answer is option D. Next question. So the next question is related to the Uniform Civil Code. Very debated topic. Many times has been reported in the newspaper. A topic which is also relevant to your mains examination, but you never know, certain type of questions can also come in your preliminary examination. Now, why this particular topic is very relevant? In 2019, when BJP party came to power, as a part of their election manifesto, they said that they'll bring in uniform civil code for the country if they are elected to power. So the central government is very much of the opinion that they wanted to have an uniform civil code in the country. And not just the central government, there are many states, especially the states like Gujarat, Uttarakhand, Himachal Pradesh, Assam. These states has been very vocal of the Uniform Civil Code. In fact, Uttarakhand has even prepared a draft version of the bill related to the Uniform Civil Code. So in this context, it becomes very, very important for us to have a good understanding of what is this Uniform Civil Code. So before I solve these statements, Article 44 of the Constitution says of the DPSP, you know that Article 44 is part of the Directive Principles of State Policy. The state shall endeavor to bring in a uniform civil code. The state shall strive to bring in a uniform civil code. So that is what Article 44 of the Constitution says. So what exactly is this Uniform Civil Code? Uniform Civil Code, if at all, if it is there in our country, right now we do not have a Uniform Civil Code for the entire country. If at all the government comes out with an Uniform Civil Code, that would mean that the people of this particular country, irrespective of their religion, would be governed by a same or almost similar set of laws with regard to their personal matters. Right now, the laws that is governing their personal matters, especially with regard to their marriage, divorce, maintenance, inheritance, etc. are not the same. The laws vary from religion to religion. Say, for example, for Hindus, we have Hindu Marriage Act. For Christians, we have Christian Marriage Act. For the Muslims, they have the Shariat law, the Muslim personal law. So, especially with regard to their personal matters, the law is not the same. Although with regard to the criminal matters, the law is the same for the entire country. We have the Indian Penal Code, we have the Criminal Procedure Code, which is applied uniformly throughout the country. And in most of the civil matters also the law is uniform, but especially the civil matters related to their personal matters, the law is not uniform. So what Uniform Civil Code or Article 44 aspires is to bring in a uniformity with regard to this personal matters also throughout the country. But we know that Article 44 is part of the DPSP is merely a directive. It is no way binding upon the government to implement these directives. In fact, the debate of Uniform Civil Code is not a new debate. It is old. It is as old as the debate that has happened in the Constituent Assembly. Even in the Constituent Assembly, there were certain members who wanted to have this Uniform Civil Code for our country. But however, the majority members in the Constituent Assembly decided that although it is a very liberal thought, the majority members in the Constituent Assembly thought that the time is not ripe to have a Uniform Civil Code on the backdrop of what has happened just before the Constituent Assembly was established and just before India became independent, that there was partition and there was a lot of communal riots. And hence, they don't want this thing to happen, that anything that is uniform can lead to what is known as imposition of the majoritarian culture upon the minorities. So, the Constituent Assembly were averse to this particular danger, and hence they thought that we will bring in Uniform Civil Code, but we will put that as a part of the DPSP. We will have that in the Constitution, but in DPSP. That means as and when the situation is ripe, the government shall bring in a Uniform Civil Code. Now, after the Constitution came into force, the governments have taken effort to bring in, but till this point of time, the Uniform Civil Code has never been a reality. Now, which is the objective of the present government and some of the states which is ruled by BJP party, which is also very vocal about this Uniform Civil Code. Now, in fact, this Uniform Civil Code was also looked into by the Supreme Court in certain cases. Some of the cases like the Shah Banu case in 1985, the Shayara Banu case in 1995. So, all these cases are also very, very important in this particular context, where the Supreme Court has also been vocal about the Uniform Civil Code because of the legal complexities that arise because of having different laws for different religion. So, in this context, let us try to solve this particular question. Statement 1, under the Constitution, it is legal obligation. It is a legal obligation for the state to ensure a uniform code in personal matters in the long run. So, there is no legal obligation. It is only part of the directive principles of state policy. It is just a moral obligation and not a legal obligation. Statement 2, only the parliament is empowered to bring an uniform civil code and not the state legislature. It doesn't matter. Article 44 is a directive that is given in the Constitution for the state. And the word state includes both the parliament as well as the state legislature. So, both the parliament and the state legislature can also make laws. So, only parliament means it is wrong. So, for which should also have an understanding of Article 36 of the Constitution and Article 12 of the Constitution, which defines as to what is state. In both the cases, the definition of state is the same under the Constitution. So, this particular statement is also wrong. So, which of the statements given above are incorrect? The incorrect statements would be both 1 and 2. Next question. So, the next question is related to the topic Doctrine of Essentiality. So, we'll have to understand as to what is this Doctrine of Essentiality. The question is saying the term Doctrine of Essentiality has sometimes been in use. It is related to what? And this Doctrine of Essentiality in the recent years has been reported in the paper for many reasons. So, recently I could recall that it was there in the Sabrimala case. The Sabrimala case was decided by the Supreme Court, but the matter is again referred to a 7-judge bench to look into the issue of Sabrimala and also to look into what is this Doctrine of Essentiality, whether the court is empowered to decide the Doctrine of Essentiality in the religion. So, basically, we'll have to understand as to what is this Doctrine of Essentiality, and it was also reported recently in the hijab case that has happened in the state of Karnataka, where in certain government institutions, the Karnataka government order said that they should not wear the headscarf, that is the hijab. And subsequently, it was challenged in the Karnataka High Court. and the Karnataka High Court declared that wearing hijab is not an essentially religious practice. So in this context, it is very important as to what is this doctrine of essentiality. So let us try to understand that the doctrine of essentiality is nowhere mentioned in the constitution. It is a judicial innovation. The judiciary innovated this particular doctrine in the Shirur Mutt case in 1954. As per the opinion of the Supreme Court, every religion has two things. One is the essential practices within the religion, and there are certain non-essential practices within the religion. So this is the observation that is given by the Supreme Court in this particular case. But to understand why the Supreme Court should actually come out a doctrine saying that there are certain essential practices in the religion and certain non-essential practice, for which we'll have to understand the scope of Article 25 in the Constitution. Article 25 of the Constitution provides religious rights to all the individuals in our country, where they have the right to practice, profess and to propagate the religion. But however, the Constituent Assembly made it very clear, this right to practice, profess and to propagate the religion is not an absolute right. It can be restricted on the grounds of what? Public order, health, morality, and also on the grounds of violation of the other fundamental rights. So basically these are the grounds on which it can be restricted. So that means on the one hand, certain amount of religious rights are given to the people, but at the same time this right is not absolute. It can be reasonably restricted by the state, and that's why we also say that in India the state can interfere in the matters of religion. India of course follows what is positive secularism. It is not a complete separation model. But however, to what extent the state can interfere? If the state interferes too much in the matters of religion, then also it is problematic, because religion is a very sensitive matter. In fact, in order to balance this very sensitive matter, the Supreme Court came out and innovated a doctrine which is called as the Doctrine of Essentiality. That means under the religion, there are certain practices which are very essential, very important. So in the opinion of the Supreme Court, what are these essential practices? That there are certain rituals and certain practices which are integral to the religion and without which the religion cannot exist. The practice of religion itself is not possible if these practices are done away with. And there are other practices and other rituals, even if they are removed from the religion can still exist. So that is the non-essential practices. So the Supreme Court said in the Shirur Mutt case that whenever it comes to an essential religious practice, probably the state shall not interfere. But if it is a non-essential practice, the state shall interfere. So the same principle was applied in all these cases, both in Sabrimala temple case, where they are not allowing the women to enter into the temple, into the main shrine of the temple. And when this argument came, the Supreme Court said, okay, prove that it is an essentially religious practice, where the court did not find it to be an essentially religious practice. So the same thing happened in the hijab case in Karnataka High Court as well. Okay, prove that wearing headscarf or this hijab is an essentially religious practice, probably will allow that. But finally, the court is not convinced that it is an essentially religious practice. But however, the biggest criticism to this doctrine of essentiality is, ultimately the court has taken itself the responsibility and authority of determining as to what is an essentially religious practice. Now the critics say, what competence does the court have to determine as to what is an essentiality? The judges may be an expert in the matters of law, but they are not experts in the matters of religion. So it is beyond their competence, and hence they should not be the authority to decide this. And not only this, what methodology do you use? In certain cases, you follow the religious text and determine whether it is under the principle of essentiality or not. In certain cases, you have followed the empirical evidences, the behavioral pattern of the people. And hence the methodology that is used by the court is also not uniform. That is also another criticism. Okay. So these are all the few important facts and the analysis that you should know to answer any question that can come from this essentiality. So with this, let us try to answer the question. So the term doctrine of essentiality has sometimes been in use, is related to most important directives which the state has to implement under the DPSP. So that is not true. The power of the parliament to make laws beyond the scope of beyond the scope of the 7th schedule. So there is no such provision in the constitution. In fact, the parliament can make laws only on those areas which is mentioned in the 7th schedule. And statement C, the power of the higher courts to declare certain rituals and practices within the religion is important. Oh, this is true. Okay. So the right answer is option C. We'll move to the next question. So the next question is related to the topic of sedition. Again, it may be relevant to both your mains as well as your prelims examination. Sedition is in news for a number of reasons. A number of cases has been filed against various activists in our country on the ground that they have engaged in sedition. And one of the biggest criticism of this particular law is that the conviction rate has been very, very low. The conviction rate has been less than 3%. That means out of 100 person who is accused, only 3 or 2 to 3% get really convicted in a court of law, and hence this provision is largely misused in the opinion of the critics of the sedition law. So on the same ground, a number of PIL, public interest litigation, was filed in the Supreme Court, and now the Supreme Court has taken up this particular matter. It has sought the response of the government in this particular matter, and the government has in its affidavit said that they are willing to change the provisions of the sedition law. So after such an affidavit was filed by the government, or they have accepted that they'll have a relook about the sedition law on the light of the criticism that is there, and after such an affidavit was filed by the government, the Supreme Court has now directed all the authorities, the law enforcement authorities, to suspend the trial of all the sedition related cases. Okay, so this is the latest development that is happening in our country, although the validity of sedition law is still pending in the Supreme Court. Okay, so under this on this background, let us try to understand some of the provisions of this sedition law. So first, let us try to understand as to what is sedition. Now sedition means any word of expression or any form of communication. It can be through word of mouth or in a written form, or it can be in any other form of expression which is trying to bring a hatred or disaffection or disloyalty towards the state, then that can be seen as sedition. So when the sedition was brought in, it was brought in 1870 under section 124A of IPC. In fact, it is a colonial legislation which was brought in mainly to use this provision against the freedom fighters who are very vocal and who are very critical about the British ruling the Indians. But however, even after independence, we continued with this law. The maximum punishment can be up to life imprisonment for sedition under the law. So now there is a lot of criticism against this sedition law in our country, because as I already said, it is majorly used against the critics who are very critical about the government. Irrespective of the government that is there in power, the conviction rate has been very, very less. So under such a circumstances, we'll have to understand. And in fact, many times this sedition law was challenged and it has gone to the Supreme Court, and many times, although the many individuals were not found guilty of sedition, but the sedition as a provision was upheld to be valid. And one such important case is the Kedarnath case in the year 1962. In 1962, in the Kedarnath case, the Supreme Court gave its stamp and approval to sedition as a valid provision. But at the same time, in the Kedarnath case, the Supreme Court tried to prevent the misuse of this sedition law, because the Supreme Court found that the definition of the sedition is very vague, and hence they have given certain guidelines to prevent the misuse. How? The Supreme Court has made it very clear that mere criticism against the government, however strong it can be, cannot be seen as an act of sedition, unless and until individual is also trying to incite, or there is a call for violence in addition to the criticism against the government, then only it can be seen as sedition. So mere criticism cannot be seen as sedition, but along with the criticism, along with that particular act, there is a call for incitement against the government, or there is a call for violence against the government, then it can be seen as an act of sedition. Okay. So that means the court has also recognized the right to criticize against the government without inciting violence against the state. Okay. So this is till this point of time, as to how the sedition is governed in our country, although now all the sedition related cases has been put on suspension by the Supreme Court. So now let us try to understand the following statements. Students who are preparing for their mains, in addition to the Kedarnath case, there are a number of cases. So till the last the high profile cases of the journalist Mr. Vinod Dua, who has also been declared not to have engaged in an act of sedition. So you can follow up all those cases, but for the prelims you should just have the basic idea. Statement 1. Presently it is a criminal offence under the IPC where the punishment may extend up to life imprisonment. Okay. So still it continues to be a criminal offence. Although the matter has been kept under suspension, the Supreme Court has not declared this provision to be void. Okay. So statement 2. Seditious speech may be a ground for restricting the right to freedom of speech and expression. This is very much true, because please understand, although sedition is not directly mentioned as a ground for reasonable restriction, the very intent of bringing this sedition is to protect the public order, because if there is an incitement to offence or if there is a call for violence against a state, then it can affect the public order in the society. So anybody who is trying to disturb the public order through their speech, their right to freedom of speech and expression can be restricted. Okay. So this particular statement is also right. Which of the statements given above are correct? So the right answer would be both 1 and 2. Next question. Which of the following statements are true regarding the ordinance making power of the president? So why this topic is very important? For two reasons. One is there's a lot of ordinance which is promulgated by the President of India in the last few years. And also recently the PRS legislative research a not-for-profit organization which is engaging in basically the research of the various legislative policies in our country. So they have recently submitted a report that Kerala is a state, as per their data of 2021, which has been published recently. Kerala is a state which has promulgated a large number of ordinances, and this is despite the fact that there is a strained relationship between the government of Kerala and their governor. Okay. So in this context, this becomes very important for your examination. So let us try to solve the questions. The moment we talk of ordinances, two important articles which has to come to your mind. One is Article 123 and other is Article 213 that deals with the ordinance making power of the president and the governor respectively. Okay, so with this, let us try to solve the questions and then let us try to understand the ordinance making power. Statement 1. Promulgation of ordinance is a discretionary power of the president and the governors. So in fact, under Article 123, the president has the power to promulgate the ordinance. Under Article 213, the governor has the power to do the same, but it is not their discretionary power. It is neither the discretionary power of the president nor the discretionary power of the governor. So in both the cases, they have to strictly act in accordance with the aid and advice of the Council of Ministers. And in fact, even the Council of Ministers cannot misuse this particular power, because the Constitution says that only when the Parliament is not in session or any of their house is not in session, or if the state legislature is not in session, then only they can use it. But although now, even when it is in session, when there is too much of legislative business, they can still take this particular route of ordinance after the DC Wadhwa case. But otherwise, normally it cannot be misused. It is definitely not the discretionary power of the president and the governor. So what is the rationality behind this? That the government should not be brought to a standstill at any point of time, whether the Parliament is in session or not in session. Under the Constitution, it is for the legislative body to make laws. But what if the legislative body is not in session? And then the executives are empowered to make the laws. But this law is just a temporary law. It's not a permanent law, because the permanent power is only with the legislative body. So anyways, this particular statement is wrong. Come to statement number 2. Repeated repromulgation of ordinance is recognized in the Constitution and by the courts. No. As I already said, it is only a temporary law-making power which is given in the hands of the executives. When the Parliament is not in session, okay, you make the law to temporarily meet the requirement. But once the parliament comes to session, you'll have to place that law in the houses of the parliament or in the state legislature, and you'll have to seek the approval of the parliament and the state legislature. Within how much time you'll have to seek the approval? You'll have to seek the approval within a period of 6 weeks after the houses of the parliament comes to session. That's the time that is given under the constitution. You cannot keep on repeatedly repromulgating the ordinance. In fact, two significant cases. One is the DC Vadwa case in the year 1985 and the Krishna Kumar case recently in 2017. In both the cases, the Supreme Court reiterated that repeated repromulgation of ordinance is a fraud on the constitutional power. So you cannot do that. Okay. So this particular statement is wrong. Statement 3. Ordinance is only a temporary legislation and must be approved by the legislature within a period of 6 months after it is promulgated. So it is not within a period of 6 months. So ordinance is temporary legislation, that is true, and must be approved by the legislature within a period of 6 weeks after both the houses comes into session. Okay, so this particular statement is also wrong. Fourth statement, ordinance making power of the president and the governors is coextensive with that of the power of their respective legislature. This is very much true. That means on all the areas on which the parliament can make law, the president is empowered to issue the ordinance. And on all the areas on which the state legislature can make laws, the governor is empowered to issue the ordinance. That means basically whatever the item that is mentioned in the 7th schedule of the constitution, the respective legislature can make laws, and similarly on those areas, the president and the governor can issue the ordinance. Okay. So this is the understanding you should have. So choose the correct answer from the quotes given below. So it is asking for which of the following statement is true. So the answer is only option 4. Next question. Again an important question. Advanced directive was recently reported in the news, which is related to what? That is the question is all about. So this advanced directive can also be called as what is advanced medical directive. So don't get confused if they just use the word advanced directive. It is also called as advanced medical directive. Once you see the word advanced medical directive, your guess can be very easy even if you are not aware of. It is related to euthanasia. So what is this advanced medical directive and why it was there in the newspaper? So we'll have to understand few things related to this. In the year 2011, in a case which is called as the Aruna Shanbagh case, passive euthanasia was recognized in our country. Passive euthanasia. The passive euthanasia was legalized in our country, and that means the Supreme Court recognized right to life under Article 21 also includes the right to die with dignity. So in this case, in the Aruna Shanbagh case, a PL was filed and plight of Aruna Shanbagh was brought to the notice of the Supreme Court, where she was in a state of coma for more than 40 years. And she was in a permanent vegetative state and she was not able to help herself. She was completely dependent on others for all the work. And this was brought to the notice of the Supreme Court, and it was informed that the life that Aruna Shanbagh is living is not a dignified life, and hence the right to life under Article 21 should also include the right to die with dignity under Article. It also includes the right to die with dignity. So this was accepted by the Supreme Court, and the Supreme Court recognized what is called as passive euthanasia. So for which, first we'll have to understand as to what is euthanasia. Now euthanasia means medically terminating the life of the patient in order to help the individual to relieve of his suffering or the pain that he is undergoing. People who are in permanent vegetative state, people who are brain dead, people who are in coma, in order to relieve them of their suffering, this euthanasia can be administered. So that is medically terminating the life of a patient, which is called as euthanasia. And this euthanasia can be classified into two types. Broadly, one is active euthanasia, another is the passive euthanasia. So the difference between these two things is only in terms of the procedure that is adopted. In active euthanasia, something is actively administered. You inject a injection, a lethal injection, and bring the life of a patient to an end, that is active euthanasia. Passive euthanasia, you fail to do some duty and thereby the life of the patient is brought to an end. So for example, the patient is kept in oxygen support system, you relieve the patient of the oxygen support system, you don't replace that once the oxygen supply is over, then that can be seen as passive euthanasia. What is legalized in our country in the Aruna Shanba case is only the passive euthanasia. And subsequent to the recognition of passive euthanasia, in the year 2018, a case was filed by NGO. It was filed long back, but the judgment was given in 2018, which is also called as NGO Common Cause. In the NGO Common Cause case, the Supreme Court recognized the right to give advance medical directive. Advance medical directive. So what is this advance medical directive? The advance medical directive is a kind of a living will that the patient, when he is in a able mental state, he can give some directives as to what has to be done in the future, what kind of medical treatment is to be administered to him in the future, whether to administer or not to administer euthanasia in the future. So all these directives can be written by an individual when he is able to take a conscious decision. So this was recognized by the Supreme Court as a part of their right under Article 21. So this is what is the development that has happened in 2008. But now why it has become relevant? In the month February 2023, the Supreme Court has given further guidelines and it has relaxed the criteria, or it has relaxed the guidelines as to how to carry out this euthanasia or the advance directive that can be written by the patients. Okay, so the guidelines has been relaxed by the Supreme Court recently, and that is why it was in news. So what is the answer? Advance directive was recently reported in the news. It is related to euthanasia. So please cover up all these topics. It can be very important. Next question. So the next question is related to the National Commission for Scheduled Tribes. Why this was in news? Recently, the Ministry of Tribal Affairs, in the month of February 2023, they came out with a report saying that presently the National Commission for Scheduled Tribes, which is a constitutional body established under Article 338A of the Constitution, functions with less than 50% of the sanctioned strength. And this National Commission for Scheduled Tribe has an important role to play under the Constitution, which I'll subsequently discuss. Not only this, yesterday only I have come across a news report that the 3 tribal women in the state of West Bengal has been made to crawl, and the reason is not yet very clear. The newspaper report says that there's a political motive behind this, but not sure. But however, one thing that is important for the examination is, now this matter has been brought to the notice of the National Commission for the Scheduled Tribe. Because one of the important functions of the National Commission for Scheduled Tribe under the Constitution is to protect and to investigate the cases of violation of rights of the Scheduled Tribe population in our country, both their constitutional rights as well as any of the other legal rights. So in this context, the function of this commission or the commission itself is very important for the examination. So the National Commission for Scheduled Tribes, you should remember Article 338A. In fact, under the original Constitution, there was no specific commission for the National Commission for Scheduled Tribe. There was only something which is called as the National Commission for the Scheduled Caste under Article 338 of the Constitution, which has to take care of the rights, the violation of rights cases, not only for the scheduled caste, but also for the scheduled tribes and the Anglo-Indians. But today, after the 89th Constitutional Amendment Act in the year 2003, this article was amended and a new article was inserted, Article 338A, only to take care of the these scheduled tribes. So what basically is the roles and responsibilities or the functions of this National Commission for Scheduled Tribes? They have to look into the cases of violation of rights of the scheduled tribe. They can make policy research and they can give policy inputs to improve upon their life. So these are the 2 major functions that they perform, and they can also spread awareness about the rights of the people belonging to the scheduled tribe. So these are the functions majorly that is performed by the National Commission for Scheduled Tribes. In order to perform their function effectively, the National Commission for Scheduled Tribe has also been given the powers of the civil courts. That means they can summon anyone, and if people don't appear, then they can take action against them. Okay, so all these powers are given to the National Commission for Scheduled Tribes. And if you briefly look into the composition of this particular commission, which is exactly was reported in the paper, it usually consists of a chairman, a vice chairman, and 3 other members who are appointed by the President of India. So this is the basic understanding that you should have. With this information, let us go to the question. So first statement, the commission is established under Article 338 of the Constitution. So it is not under Article 338, it is under Article 338A of the Constitution, with an objective of safeguarding the rights of the scheduled tribes. So that's true, but the article is not right. Statement number 2. The chairperson and the members of the commission are appointed by the central government on the recommendation of the Parliamentary Committee on Tribal Affairs. No, although there is a Parliamentary Committee on Tribal Affairs in the Parliament, that committee has no role with regard to the appointment of these members in the National Commission for Scheduled Tribes. They are all appointed by the President on the advice of the Prime Minister. Okay, so this particular statement is also wrong. Which of the statements given above are correct? So none of these statements are right. So the answer is neither 1 nor 2. Okay. Come to the next question, the last question for today. Consider the following statements. But this question is related to the reservation of jobs in the private sectors. So many states are now following this particular thing, that they are trying to reserve the jobs in the private sectors for the local residents in that particular state. Haryana has already made a legislation. Haryana has already made a legislation. They are trying to give 75% reservation in certain private sector jobs only to the local residents. Jharkhand has already came up with such a bill. The same is true with Madhya Pradesh also, and I think the other states are also having this idea of reserving the private sector jobs to the local residents. So in this context, let us try to understand as to what is the constitutional implications of such reservation. So this reservation, is it violating Article 16 of the Constitution? Because Article 16 of the Constitution says that there shall be equality of opportunity in matters of public employment. Now please understand, it does not impact Article 16 of the Constitution, because Article 16 only talks about equality of opportunity in matters of public employment, that is employment under the state, under the government services, but not in private employment. So that is one aspect that you should be very clear. Now the second aspect of this particular thing is, even in the public employment, can there be reservations? Within the public employment, can there be reservation to the local residents? Both the things are possible. Article 16 clause 3 says that even in public employment, certain jobs can be reserved for the local residents. Very much possible. There is an act which is called as Public Employment Requirement as to Residence Act. So certain jobs in the states like Telangana, Himachal Pradesh, in all these states, Tripura, in all these states, certain jobs has been reserved only for the local residents. Okay, so that is possible. But however, you have to understand, such a law can be made only by the Parliament to reserve the jobs, and not by the state legislature. So this is very important. Second thing, in public employment, can there be reservations to various castes like scheduled caste, scheduled tribe, and the other backward castes? That is very much possible by virtue of Article 16 clause 4. And now this reservation is also available to the EWS category by virtue of Article 16 clause 6. So what is this EWS? I will discuss that separately in another question. So with this information, just come to these questions. Statement 1. The reservation in private sector jobs to the residents of a state is violative of the fundamental rights under Article 16. So it is not violative. Reservation in the public employment may be violative, but again there are exceptions, because Not only we follow the principle of equality before law, the Constitution also provides for equal protection of laws. That is the idea of social justice that we have already discussed. Statement number 2, the Constitution empowers the Parliament to reserve jobs for the residents of a state in public employment by law. So the Constitution empowers the Parliament to reserve jobs for the residents of a state in public employment by law. That is true, which we have seen that this can happen under Article 16 Clause 3. So which of the statements given above is incorrect? The incorrect statement is option 1 only. Okay. So with this, we are done with the discussion for today. So we'll continue with the discussion for few more classes. We'll cover 100 questions. The idea is to empower you to attend most of the questions from the Indian polity. To get more updates about our classes, you can also subscribe to our StudyIQ English channel. And all the best to all of you. Thank you very much. God bless.